by the people, for the people, the gathering to get healthcare now. Chapter 22, Accounting and Legal within the IPA. In the 70s, 80s, and 90s, many IPAs had contracts to do delegated claims and delegated credentialing. They were the administrative offices of the insurers with which they held contracts. They bought computer systems that tracked eligibility and claims, and the data from that fed their general accounting programs. In the 90s, there were many failures of the types of IPAs, and the insurers stopped delegating claims. They did not like paying the IPA a lump sum of 85% of the premium and then having to pay the hospitals and physicians again after the IPA failed. The transfer of risk did not work very well. The realization by the insurers and the regulators that claims were going to have to be handled by the insurer meant that the IPA contracting and accounting was going to become less complex and less risky. As expected, greed is usually why systems collapse under stress. Insurers enter into risk agreements and delegated claims to the IPAs because they did not want to get into the details of how an at-risk medical group must operate as compared with an indemnity insurer. They reasoned that if the IPA put up a substantial letter of credit, had a claims payment system, and accepted a gross capitation payment for provision of medical and hospital services, the insurer could have a profit regardless of the losses the IPA might suffer. This is the same kind of thinking that is manifest by CMS and the ACO programs in which they push risk contracts. That was greed, and it did not work. You might say that it was stupid as well, but the people who were doing it were not stupid and had made substantial profits in the kinds of contracts in the past. It's a little like our current banking mortgage failures. Greed followed by relaxation of standard underwriting, followed by business changes focused on more profits and not on the service that was supported by the enterprise. A distributist approach to this problem would have management of services and funds on a much smaller scale with more eyes on the processes, which is why Shoemaker uses the phrase, small is beautiful. It's possible to do other businesses without the advice and support of a lawyer. However, a lawyer is indispensable to an IPA. IPAs contract with corporations and physicians that are much stronger financially than the IPAs. The weakest party at the table must have a good legal advice and support. Will Durant said, "Animals consume each other without qualm. Human beings do it through due process of law." The amount of money involved in funding an IPA can bring out the vultures in times of stress. There are many complex documents needed to conduct this kind of business. All the documents we have seen have been written and rewritten several times by lawyers working for very large insurance companies and IPAs. Further, the contents must be reviewed and approved by both CMS and the insurance departments of the states in which the companies operate. Even though your lawyer must be a wordsmith, participants cannot be passive about what needs to be explained and whether it's necessary. Too many patients and physicians simply give up when they read detailed contracts, yet some team leaders must have a thorough grasp of the contracts. The contracts are the full expression of the business and the group intends to undertake and which the IPA might need to defend. Fear that an attorney will charge too much is the same as the fear that a doctor or a CPA will charge too much. All such professionals require about $200 to $300 an hour to pay themselves and their overhead. They don't always get that much, but it's a common rate. Doctors arrive at their rates through piecework, billing, the CPT codes, but lawyers and CPAs automate their time tracking and bill you for the time they are awake and thinking about the job. The alternative way is to pay both lawyers and CPAs a capitation. Several years ago, a law firm in Austin we know contracted with a dental HMO, and the firm accepted $1 per member per month. And over time, as the plan grew in membership, the dollar was far more than the hourly rate for their routine work. Our company contracted with the law firm for 75 cents per member per month, and it worked to the advantage of the IPA in several ways. Over a 12-year period of caring for 4,000 to 10,000 members with various companies, we experienced 4 cases where the companies left the market or failed, putting our deposits or accounts receivable at risk of being lost. Having an attorney who was on a retainer and who had a vested interest in preserving our income saved us more money than our company ever paid him. In cases where the companies went out of business, our attorney reduced our settlement with one company by $100,000, and from another company he was able to get a judgment in bankruptcy court for $150,000 when one of the officers of the company failed a fiduciary accounting role with us. The officer knowingly approved a payment from reserves that was not due from us. In cases involving companies that had left the market, our attorney got new contracts done and approved with new carriers so that the patient base of 4,000 senior lives was retained. Ultimately, the move of those 4,000 patients earned more than $6 million in the subsequent 4 years. Engaging the lawyer in a novel way is the same as finding a medical team that sees itself as an intimate part of the IPA, and the care of the patients is a priority. Contracting with a lawyer places someone on your team who has no motives for promoting litigation, who can talk with other lawyers in a factual and confidential way.